If a defendant is raising an objection, you don't say because you want to deliver judgment, you want to end the case, you go ahead and deliver judgment. When in section 36 of the 1999 Constitution, it says that the defendant must be given adequate time and facility to prepare for his defense. There are times when the judge
he was given more than enough opportunity.
No.
Especially when he said he wanted to defend himself. The judge kept telling him
when he filed the objection, the motion to challenge jurisdiction, the judge refused to hear the motion. Objection can be brought at any point before judgment.
Wow.
Not because lawyers just kept quiet. You can't. This is the first judgment that we are putting something on nothing and expecting it to stand. It cannot stand. This has nothing to do with emotions. And the fact that a defendant is unruly in court, uncultured and mannerless, does not give the court, does not empower the court to pass judgment against him. The court will charge him for contempt or any other remedy available to the court. So because I've heard people say because he was unruly, that is why the court had to quickly. That is judicial blasphemy. To convict a man because he's unruly. No.
See, it's actually interesting, Barrister, you're saying. Yes, Barrister, sorry to cut in here. It's actually very interesting as you fleshing out some of these things and expose them as much as you can. But as a lawyer, is it fair to say that at this point you are questioning the intellectual dexterity of Omotosho SAN at this point, and knowing what he had going on?
Very well. What do we do on appeal? I can talk like this now because the case has ended. And they have not filed appeal. They are filing today or tomorrow. The reason lawyers cannot talk outlandishly before night because the matter is sub judice. When a court lacks jurisdiction, it lacks everything. There is an absolute miscarriage of justice in that case. Nothing comes from nothing. You cannot pull something from nothing. Nothing is equal to nothing. The judgment itself did not follow the basic legal principle for which we ought to have followed. When you look at the spread of the case, there are three fundamental issues. First, the law upon which he was charged had been repealed. Okay, so the statutory absence of the existence of that law itself, foils that issue. Okay, two, the objection raised by Nnamdi Kanu in terms of the objection that relates to that the court lacks jurisdiction to that effect was not adhered to by the judge. Present objection under the law. Once it is brought, the law says that it can be raised at any point before judgment. So, and once it is raised, the court must first of all suspend whatsoever it is doing to attend to that. When the issue of jurisdiction is raised, the court must first of all assume jurisdiction to determine whether it has jurisdiction or not. That was not done. The third one has to do with proof beyond reasonable doubt, the material evidence, the nexus, that the unequivocal evidence that's supposed to link Nnamdi Kanu to the charge was not there. Like the lawyer said, there was no weapon. Even when you go beyond that, there was nothing direct. You are saying he made this statement, he made that statement. All those whom were affected, nobody was called as witness to testify. So the court solely relied on circumstantial evidence under the Evidence Act. Circumstantial evidence requires corroboration before it can be fit for conviction. So when you look at the case in its totality, these three defects deflate the argument put forward by that judgment for the conviction of Nnamdi Kanu.
A very big win for Mazi Nnamdi Kanu. Another learned lawyer raises serious alarm over miscarriage of justice. Before we continue watching this very interview, let's understand the basis of what the lawyer is talking about. He describes the conviction of Mazi Nnamdi Kanu as nothing short of a total miscarriage of justice. You all remember in our previous video, a constitutional lawyer broke down the judgment and exposed what he called deep legal contradictions and judicial errors. Now, another legal expert has stepped into the spotlight, reinforcing those concerns with fresh legal arguments that shake the foundation of the entire conviction. According to this very lawyer, there are three fundamental legal principles upon which the judgment rests. According to this lawyer, he says that three fundamental legal principles upon which the judgment were actually carried out are fatally defective. What does that mean? It means it doesn't have any stance. First, he states that the law under which Nnamdi Kanu was charged had already been repealed. Just like what I told you, Nnamdi Kanu, insisted that the law through which he's been charged, he's been tried, is a repealed law, making the prosecution legally questionable from the very beginning. Secondly, the lawyer also alleged that the court failed to properly address Kanu's critical objection on the question of a jurisdiction, a preliminary issue that must be resolved before a court can lawfully continue any trial. And lastly, the lawyer also argues that the key material evidence allegedly linking Kanu to the charges, including the so-called evidences that is presented to the court by the prosecution, was never properly established in the court. As a result of this very legal principle that is being deflated, he insists that there was no credible proof that the accused, being Nnamdi Kanu, committed the offense as alleged. And under Nigerian law, the prosecution must prove its case beyond reasonable doubts, not by suspicion, not by theory, but by solid and reliable evidence. It means the prosecution must prove guilt so clearly that no reasonable person can doubt the truth based on the evidence presented. And I ask, Omotosho, where is the evidence that was presented before you by the prosecution? Help me in the comment section. Ask Justice Omotosho, where is the evidence that was presented to him by the prosecution that made him to jail Mazi Nnamdi Kanu? According to this lawyer, the court relied heavily on a circumstantial evidence, which under the Evidence Act requires strong corroboration before it can sustain a conviction. In the words of this very lawyer, these three defects alone are sufficient to collapse the substance of the judgment. Ladies and gentlemen, let's now continue watching the interview as this lawyer lays it all bare and clear.
In criminal cases, the law says that you cannot charge someone for an offense not known to law, and you cannot charge someone for an offense that is not in a written law. So if you are charging someone on a law that has been repealed, and you have that in your charge sheet, what you need to do is to first of all address that as a prosecution counsel or the prosecution team, which was not done. Okay, criminal trial requires proof beyond reasonable doubt. It is not enough to say he made statements. To whom did he make the statement? Where are the witnesses? Where are the evidence? Okay, upon his conviction, on what basis are you arriving at his guilt and thereafter his conviction and sentencing? Okay, so we don't, in law, you cannot, apply speed and kill it on the altar of technicality. So the court, I absolutely agree with the lawyer that that judgment is sitting on a very wrong tripod, because by the time you clear those three angles, three aforementioned angles, there's nothing left of that judgment, because it is political. Perhaps there is a pressure to score points, but the law does not see it that way. Whether a matter is political or not, even if a matter is political, it must conform to legal process, legal proceedings. If a defendant is raising an objection, you don't say because you want to deliver judgment, you want to end the case, you go ahead and deliver judgment. When in section 36 of the 1999 Constitution, it says that the defendant must be given adequate time and facility to prepare for his defense. There are times when
he was given more than enough opportunity.
No.
Especially when he said he wanted to defend himself. The judge kept telling him
when he filed the objection, the motion to challenge jurisdiction, the judge refused to hear the motion. He was given enough time to enter his defense, but he opted for a motion.
So what's the difference?
To challenge jurisdiction. Yeah, there's a difference.
Yeah.
Okay.
You are asking him to open his defense. That's to call his witnesses that he has listed. He listed many of them. You're asking to call them and have his case dispensed with. You understand? You gave him enough adjournment on that. In the process of that, he came up with a motion. He brought out a motion. He filed a motion and said that I am challenging the jurisdiction of this court. It's allowed in law. Objection can be brought at any point before judgment.
Wow.
Yes. There are times when a judge has written a full judgment, has adjourned to deliver the judgment, and will file motion to arrest the judgment. It's allowed in law. So what will now happen is that instead of the court to go ahead to deliver that judgment, the court will suspend that judgment, the substantive suit, and focus on the motion filed. Okay? And then deal with that motion to its conclusion before it goes back to the judgment. That is the law. Okay? So if that was not followed, would you still say that the judgment is sound on that? See, judgment, however sound and brilliant, that is delivered by a court that lacks jurisdiction goes to no issue. Ex nihilo, nihil fit. From nothing comes nothing. This judgment cannot be an exception. It cannot be because lawyers just kept quiet. You can't. This is the first judgment that we are putting something on nothing and expecting it to stand. It cannot stand. This has nothing to do with emotions. And the fact that a defendant is unruly in court, uncultured and mannerless, does not give the court, does not empower the court to pass judgment against him. There are other options the court ought to have turned to by contempt. The court will have charged him for contempt or any other remedy available to the court. So because I've heard people say because he was unruly, that is why the court had to quickly. That is judicial blasphemy. To convict a man because he's unruly. No.
See, it's actually interesting, Barrister, you're saying. Yes, Barrister, sorry to cut in here. It's actually very interesting as you fleshing out some of these things and expose them as much as you can. But as a lawyer, is it fair to say that at this point you are questioning the intellectual dexterity of Omotosho SAN at this point, knowing what he had going on?
Very well. What do we do on appeal? I can talk like this now because the case has ended and they have not filed appeal. They are filing today or tomorrow. The reason lawyers cannot talk outlandishly before night because the matter is sub judice. Right now, it's no longer sub judice. And when we go on appeal, what do we say? We say, see how we couch appeal. Let me tell you how we couch appeal. The learned trial judge misdirected himself. That's how we couch appeal. When he concluded or meant to, so that's how you couch appeal. The learned trial judge erred in law. Do you understand? So that is it. So you will see that the appeal will be framed around these three premises. It's a criminal matter, it's not a civil suit. Criminal matters that the penalty is a capital. You don't treat it with kid's glove. The fact that Nnamdi Kanu unwittingly said he was going to defend himself does not change the procedures and principles of law. The procedures and principles of law, they still stand. Jurisdiction is a threshold issue, is a hallmark of litigation. When a court lacks jurisdiction, it lacks everything. And one thing the law forbids is that you can't pull something from nothing. It will not work.
You are shaking the table at this point, and
yes, that is what it is exactly. The public need to know. I have an article already that will be published in Sarah Reporters in the next 1 or 2 hours, which I wrote last night. That judgment, I didn't even know it's going to coincide with what I'm going to talk about this morning. Okay, so the law have processes and procedures. That is why it is not a sound judgment to allow non-lawyers to dabble into to say I want to defend myself. It is not, because let me tell you, if Nnamdi Kanu had allowed Kanu Agabi to even do this defense, these whole issues would have been very difficult for the court to even convict in the first place because they were brought up salient issues. And see, it's not enough that people died. You must link that death to an act of terror. And you must link that terror to the defendant. You understand? Somebody said somewhere, made a broadcast somewhere that you do this, then you interpreted it to mean he incited people. You understand? Then you did not go further to prove it by saying that incited people, these are the persons that are affected, these are their testimony, these are the witnesses. this person you affected in this particular place, the broadcast led to this and the rest of that. You are just saying from here that it was the broadcast that led to the killing of police at the NSAS, or the broadcast just led to which police was killed during the NSAS. So please, we can't just sit back and say no. Hardly will you find a lawyer that supports Nnamdi Kanu's approach and his conduct and his character. His character is distasteful. His conduct is overbearing. The way he approached the matter is not acceptable. But on this issue of his trial, the prosecution hadn't proven his case. The prosecution hadn't proven his case because the prosecution is supposed to rely on the strength of his case than rely on the weakness of the defendant's case. What they did, all the evidence they tendered and the rest of that, they were not disproved or rebutted. That is why the court went that direction. And even when the court went that, the court still erred by going that direction because jurisdictional issues were pending. Lack of proof beyond reasonable doubt, the standard in criminal matter, was not adhered to. And so you can't just rush because you want to convict and then conclude that it's a complete miscarriage of justice, to say the least.
Wow. Okay. Thank you for that. So, can a life sentence stand if no arrested perpetrator linked Kanu to the alleged crimes? Can it still stand?
Can an arrested what?
Can a life sentence? He was given a life sentence. Can a life sentence stand if no arrested perpetrators linked Kanu to the alleged crimes?
That is part of what was saying, that for now the court has reached its own decision. Do you understand?
Yeah.
If Kanu does not appeal, this judgment will stand. Do you understand? However, erroneously delivered and not considering the full principles of law. But if this judgment is appealed, which is probable, you understand, it will not stand because of the legal error made by the court of first instance. So the Court of Appeal will have to look at those grounds of appeal vis-a-vis the laws that establish them, the laws that they're going to back them up with. And the Court of Appeal will take a decision whether the Court of First Instance did the right thing or it erred. At appeal, nobody's calling witnesses. It's a jury court. The Court of Appeal is looking at the decision taken by the Court of First Instance, the reason behind the decisions, okay, and the legal consideration of law that was applied by the court to the fact of the case. Where they are wrong, the Court of Appeal will point them out.
All right.
Okay.
And take a decision.
I understand.
All right. So let's take a look at some comments from Nigerians who have written here. We have one Chalo T2X who said, the people sharing Nnamdi Kanu's broadcast on social media are the ones inciting the public. So it's not the creator, the content creator, but those who share it. That's what this young man is saying.
Yeah.
And another person said, that is Anthony, said, Mazi Nnamdi Kanu is a prophet. He called him Jesus of our time. God bless Mazi Nnamdi Kanu and Simon Ekpa and one Dr. Ngozi in the United States of America. So let's get to this matter. I truly do understand that every nation comes with its constitution, the way it should do things, law and all that. But I'd like to know if this is a universal application, especially with regards to the evidence that you shared, that if someone makes a broadcast and there's no evidence that really shows that the person physically was part of what he has said, that he has no case. But in the case of Simon Ekpa, that's Finland, he was judged on the premise of all the things he said, just like Mazi Nnamdi Kanu, and jailed for 5 years plus. And equally, let's take this equally to Rwanda during the genocide era. A young man, a broadcaster who was saying, kill the cockroaches, one Kachagwa. He made himself to Canada and was repatriated back because the Canadian people said, no, we can't stand this. You can't just make statement, and as a result of that, people. These two individuals, Simon Ekpa and this man from Rwanda, they didn't actively participate in it, but because of what they created led to so many issues. In the case of Nnamdi Kanu, don't you think it equally should apply?
That offense is not just by expression. The prosecution must prove the offense. The prosecution must prove the offense. That's what I'm saying. And if the prosecution is not able to prove the offense, what it means is that the court cannot convict. Because see, when you say somebody incite, what do you mean by incitement? Is it by just framing a charge sheet?
Because
are you not supposed to call witnesses? Are you not supposed to call witnesses those who are affected thereafter as a byproduct of what has happened? You understand? So if that is not proven, and you just rely on circumstantial evidence, and you are convicting somebody for life, does it make sense to you? That's what I'm saying. So the standard of proof under our criminal law is beyond reasonable doubt. You understand? You have to establish it beyond reasonable doubt. So if you have not done that, if you have not established it beyond reasonable doubt, you cannot validly say that the person is guilty of that offense of incitement. That's what I mean.
All right. Okay, so let's hope that all of this is quite received by people who might not understand this and more. But the family of Nnamdi Kanu have said that his taken away to Sokoto is not good enough.
Yeah,
do you think? Yes. Do you think it's in our laws? It's okay for people to say or direct where people should go to?
Like that, whatever you can do is persuasive. You can say because the matter is in Abuja and he wants to file cases, he wants to file motions and all that, it will be difficult for him to file and all that. You can put up all those arguments, but you cannot decide the prison custody that the defendant is being taken to and all that. It can only be persuasive. Sorry, the convicted person now is taken to. It can only be persuasive.
Okay.
Okay. What impact could a possible clemency from President Tinubu have on national stability? So I just thought of linking this story to this particular question.
Yes.
Yes, clemency would normally one of the grounds for which President grants clemency is if there is miscarriage of justice. If the matter has political coloration that requires stability and so many other considerations. Okay, the president can do that. And that cleans the entire conviction and everything.
My last question is this, because you talked about circumstantial evidence. So I went searching, because of course there are lots of information here and there. And what I have here says that circumstantial evidence is sufficient for conviction if it forms a complete and unbroken chain that points exclusively to the guilt of the accused, excluding any other reasonable hypothesis of innocence. So does this make sense? Yes.
Yeah, excluding any other reasonable hypothesis
of innocence.
It can only be relied on if all the arrow points to the person.
So is all the arrow not pointing to Nnamdi Kanu?
No, he made a broadcast, you understand?
Yes.
But the thing is, have you proven beyond reasonable doubt that the broadcast incited people and the incitement led to the death of soldiers and policemen and all that? He was saying, if you see the Nigerian police, attack them, attack the army, kill them. Do you understand me?
Yes.
Then you need witnesses to accentuate how many soldiers were killed.
Oh, okay.
Where were they used? When? Is it before the broadcast or after? You have to link those deaths to that broadcast. Unequivocally, that's what I'm saying. They will bring evidence. Even if if people died, who died anywhere, you cannot ascribe all the soldiers that died within that period to the broadcast. You have to prove it. That's what I'm saying. We're not done.
They have to prove it exactly. Now, what does the lawyer mean? A case built on nothing can never stand on something. Nnamdi Kanu's conviction, a blasphemy to judicial system. Another learned lawyer has delivered another searing assessment of the trial of Mazi Nnamdi Kanu, and his conclusion is actually devastating. In criminal law, you cannot charge a citizen for an offense that is unknown to law, where unlawful or defective charges exist. The prosecution has a legal duty to amend those charges to conform with the law, which they never did. According to the lawyer, this never happened in Nnamdi Kanu's case, despite claims that the Supreme Court had earlier directed that that same charges, be properly amended, which they also never did. This lawyer insists that This single failure already raises serious constitutional concerns. But that is just the opening chapter. The lawyer explains that criminal prosecution, especially in a serious offense that attracts heavy punishment, capital penalty, demands proof beyond every reasonable doubt. This means the case must be proven clearly, solidly, and convincingly on every material point. It is not enough to say the accused made statements. He says, you cannot jail a man simply because he spoke. Every element of the charge must be established with evidence, not suspicion. Then he strikes deeper again. He agrees with Kanu's legal team that the entire judgment is standing on what he calls a very wrong tripod. According to him, the conviction rests on 3 defective pillars, and those pillars that is even relying on, which is also wrong, are to be removed entirely. And once those tripods are removed, nothing remains. That is to say, Nnamdi Kanu has no case to answer. So you would ask yourself, why are they not amending the same charge that the Supreme Court ordered them to go and amend? So when you break the 3 foundations, the 3 principles, the lawyer says what you are left with is not judgment, go emptiness. He further alleged that the case appears to carry political undertones, which every one of us should understand that is a substantive truth. Because as I have always maintained in my previous videos, the Nnamdi Kanu's case will never be decided within the corridor of court. The lawyer alleged that the case is political and the judgment is just to, probably to score a point. But he said whether political or not, everything has to obey the same legal rules, the procedures and principles. The lawyer made it clear that justice, he argues, cannot bend for pressure. Court must stand on law, not on sentiment. Another grave concern he raises is the alleged denial of fair hearing. Under Section 36 of the 1999 Constitution, an accused person must be given adequate time and facilities to prepare a defense. But in this case, that objection were brushed aside in a rush to conclude the trial. And that was blasphemy of justice. He says a court does not finish a case simply because it is tired of the case. And in Nigerian law, the defendant can raise objection at any point in time. So you see, because like I said it before, I live streamed this very judgment, and Nnamdi Kanu actually started acting rudely because the judge did not allow him to raise his objection. This lawyer describes the judgment as one of the most troubling in recent legal history, because in his view, no matter how beautifully written a judgment is, if the court lacks the jurisdiction, the entire process collapses. That brings us to his central thesis. He calls jurisdiction the hallmark of litigation. What does this mean? It means the most essential foundation of a court case. If a court lacks jurisdiction, it lacks power to hear the case, the authority to decide in it, and the legitimacy to rule on it. In simple words, without jurisdiction, the trial is legally dead on arrival. The lawyer also addressed the controversial behavior of Mazi Nnamdi Kanu in court. He makes it clear that Nnamdi Kanu's conduct was not proper, it was not cultured, it was not acceptable. But he insists bad behaviors does not authorize injustice, especially in a criminal case as such. A judge has lawful options. Contempt proceedings, fines, or even sanctions could be applied. And to him, conviction is not one of them. He says you don't jail a man because he offended the court's feelings. The lawyer says that was a judicial blasphemy. And let's even recall the earlier observation by Mazi Nnamdi, who has said the judgment appeared predicated on anger, not anchored on law. He adds that Kanu's choice to intermittently represent himself in court significantly weakened his defense. According to him, had former Attorney General Kanu Adabi fully handled the matter, the prosecution would have faced extreme difficulty securing a conviction. And this lesson is very blunt. Self-defense in a capital criminal case is one of the greatest mistakes an accused person can make. But the lawyer insisted, even with all the legal missteps from Kanu, the lawyer maintains one position with clarity. The prosecution still failed to prove its case. He finally issued a very serious warning. If Nnamdi Kanu does not successfully appeal this judgment, that is the only way it will stand. Naturally, this has heightened concern among supporters, especially as reports indicate that his current location in Sokoto has made filing the appeal in Abuja increasingly difficult. And we can see that the lawyers are already raising concern about the whole thing. This is from Aloy Jumako, one of Nnamdi Kanu's legal counsel. He says this is a summon to Mazi Nnamdi Kanu to be present on November 20th, on November 28th at the Federal High Court for settlement of record for the appeal he filed before November 20th judgment. A production warrant is required for the Sokoto prison to bring him to Abuja, but the court refused to issue it. As you can see, this is actually the filing. Why all this injustice? This is not what we should be, getting. As always, this is Abel Perspectives, your domain for unfiltered news and raw political analysis. Here, we give it to you the way it is. We give it to you so raw that you would have to naturally digest it. Until next time, don't forget to like this video, share, and smash the subscribe button, so you would always be the first to get notified. This time we'll drop an amazing breakdown just like this one. Thank you for watching.